forfeit your right to present a closing argument.
Under what lawful law?
So basically, Judge Darrell is trying to tell Darrell, because he's trying to raise the issue of jury nullification in front of the jury. That is completely against the law. You are not supposed to do that because they are not supposed to be biased to anything or anybody. So she's telling him if he raises that to them, then he has forfeited his right relative to a closing argument. Listen to this.
Under State versus Anthony.
That it doesn't refer to that.
State versus Anthony may not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is fully applicable.
No, you
because
can't.
The more
You can't
general
change the law, Your Honor.
principle-
You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. If you're, Your Honor.
How is she changing the law? That's applicable to any court. You can't tell a jury they have the power to nullify. You're not supposed to say that to them. What is he talking about?
You're attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument.
Wrong.
Nothing that you just named. Not
Mr.
Illinois versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I will,
me to
Your
do
Honor.
that?
I will.
All right.
Shut up.
So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor.
It don't matter that you object. And you know what? The judge really didn't even have to go over this with him. Like, she didn't have to. I think that was a delay. She could have just made her ruling, and if he would have went off, I would have just put him in the other courtroom. She did not have to waste her time like trying to show him or to prove to him that you don't have the right to tell the jury that they have the power to nullify. If he don't agree with it, then that's on him. I ain't reading no paragraph about that.
Object to that ruling.
It don't matter.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power.
Then they need to forfeit his right.
Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't
The
interrupt.
point is, it don't matter. You're not supposed to tell them that at all.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument.
It doesn't matter.
Not one.
You ain't supposed to tell the
So
jury.
how is me merely informing the jury of the power and the rights that they have?
That's because that's against the law.
How is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold
Now
up.
let me say this. Like I said, she really didn't have to even go over this whole colloquy with him over this because this is a waste of time. The other thing is, what I don't like about this is the fact that, first of all, he knows he killed those people at the Waukesha parade. And for him to suggest for the jury to nullify, so in other words, I did all of this and I'm expecting the jury just to nullify it and I just get away with all this. Come on, did he really think that he was going to outsmart the entire justice system with the jury nullification gambit? Come on. Even if he did raise the issue in terms of jury nullification, they would not have done it. I remember he told the jury one time in his closing argument, he gonna tell them, do the right thing. Do the right thing. And guess what? They did the right thing by convicting you.
Hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution.
Why? Because the prosecution is not telling them. Ah! The prosecution is not telling them jury nullification.
How's that fair? How's that balanced?
Mr. Brooks, I am squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to
I'll
that.
take it up in the court
Your
of appeal.
objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
No.
That
No.
request is denied.
May I respectfully ask for,
No.
matter of fact, I reject that ruling and take exception to that ruling.
It don't matter. It don't matter.
For the record, may I request a legal or factual basis for your
No,
ruling?
she ain't got to do that.
Not
This is-
one pertaining to.
All this is just delay. She does not have to. I can't even believe she's even feeding into this. I would have been put him in the neighboring courtroom and to get on with this case, because this is ridiculous.
Being present in the courtroom or testifying. One that specifically talks about
Put this nutcase
a
in
closing
jail.
argument.
How is he going to try to outsmart a judge? That's what I don't understand. You cannot outsmart a judge when it comes to the law.
All of those requests
Are
are
denied.
noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I
Thank you.
respectfully request a written judicial finding of facts and inclusion of law.
No, she ain't got to do that.
Denied.
Take it up in the Court of Appeals.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter.
This is not an appellate court.
I'm not the forum for which an appeal would be sought, sir.
Right. Go
I
to the
cannot
appellate
answer
court.
that.
You referred to it before.
Darrel, shut up, man.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No.
Right,
it's-
right.
I'm supposed to be in this admiralty court because you haven't.
Shut up, man. You don't even know what
If
you're
we're
talking about.
under Article 3, then we should be in common law court. That hasn't even been addressed.
Oh,
if we're in a
please.
common law court or an admiralty court.
Please.
That's a baseless argument, sir.
Based-
I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting
made
me.
a
Shut up,
rule.
Darrel.
You just tried to put me under a rule that no one else was put under.
No one else is telling the jury about jury nullification. What are you talking about?
Circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the
what are you
same
talking
rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification
Right.
has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform
in the other
the
courtroom,
jury of
please.
their power. I never once said
You're not
I'm
supposed
gonna
to
make
tell
an
them that.
argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why
nullification.
can't they be informed of their power?
Because it would violate the Bajirkas decision, sir.
Right.
Violate
Right.
what decision?
All right, sir, I am going to bring the jury
retarded.
And
out.
I'm going to
man.
inform them that they have the power.
And if you do that, I
Forfeit.
will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that. It's
argument
forfeited.
What
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've
I make
outlined
an
that
oral
to
motion
date.
for
Take it up in appeals.
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Right.
present a closing
Under
argument.
what lawful law can you?
And then if you
Shut
continue
up,
to
man.
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
being
the
held in contempt.
instruction.
You should remove him now. Now he's talking about contempt. It's like he keeps trying to keep going and going and going, and she keeps feeding into it. The jury should have been in there.
Is it civil or criminal?
All right.
See, that's a waste of time. Shut up.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I